Open any major news app today, and you are hit by a highly optimized data stream. You see continuous live TV broadcasting, aggressive breaking news push alerts delivered to your lock screen, and rapid-fire visual stories. The architecture is engineered to capture and hold attention at all costs. Driven by these competitive metrics, the 24-hour news ecosystem has shifted its primary function. Many platforms no longer limit themselves to reporting established facts regarding a criminal investigation. They actively construct narratives to shape public perception. We call this phenomenon parallel adjudication. It is an extrajudicial system operating in the public sphere that directly mimics the legal process, dissecting allegations and inferring guilt long before a formal verdict is reached. This digital environment exerts immense pressure on the physical courts. The traditional justice system, with its slow procedural safeguards, finds itself under siege by a relentless media frenzy demanding immediate answers. Media trials represent a structural feature of the modern communication landscape, a systemic outcome of a paradox embedded in constitutional law. That paradox begins with Article 19(1)(a) of the Indian Constitution. For decades, this provision has served as the ultimate shield for the press, guaranteeing the freedom of speech and expression necessary for democratic accountability. Counterbalancing that is Article 21, the constitutional bedrock that guarantees every citizen the right to life and personal liberty, which the courts have expanded to include the right to a fair trial. This graphic illustrates the historical equilibrium. A robust press scrutinizes the state, while the legal system protects the individual. But under the weight of algorithmic amplification and constant broadcasting, the scale breaks. The media's expressive power overwhelms procedural protections. To understand why the current doctrinal framework fails to resolve this tension, we have to deconstruct the exact architecture of a media trial. We must isolate the precise anatomical differences between legitimate investigative journalism and public adjudication. Legitimate investigative journalism acts as a democratic watchdog. Consider the SIT probe into the recent donation theft allegations at the Ram Temple in Ayodhya. Standard reporting focuses on the mechanics of the investigation. Journalists trace the flow of funds across bank accounts, analyze administrative accountability, and report on the timeline of evidence collection. They scrutinize the state's conduct. A media trial abandons this evidentiary discipline. It moves the process out of the field and into the television studio, simulating legal reasoning to pronounce moral guilt directly to the viewing public. This model maps the specific architecture of parallel adjudication. It relies on four distinct structural features. The first requirement is temporal proximity. The media engages with an active, ongoing criminal investigation, matching the legal timeline step by step to maintain high audience interest. Second is narrative construction. The coverage extends far beyond verified public records. Broadcasters use leaked call logs, speculative psychological profiling, and emotive framing to build a compelling story. Third is simulated reasoning. Studio debates adopt courtroom aesthetics. Moderators act as interrogators, and panelists act as prosecutors, but they operate entirely without cross-examination or the rules of evidence. Finally, public mobilization. The coverage is designed to solidify public sentiment, which in turn creates immense institutional pressure on investigators, witnesses, and judges to align with the popular verdict. By combining these four pillars, parallel adjudication replaces the rigid protective flowchart of the courtroom with the raw, unchecked power of algorithmic amplification. If this parallel system so clearly undermines the judicial process, why do courts hesitate to shut it down? The answer lies in the early years of the Indian Republic. The constitutional framework was forged in an era characterized by a deep historical trauma regarding authoritarian control and state censorship. Early Supreme Court decisions, such as the Romesh Thapar case, established a profound hostility toward prior restraint. The judiciary decided that stopping a publication before it goes to print is an inherent threat to democracy. This graph displays the current doctrinal test. Article 19(2) allows the government to restrict speech, but the legal threshold demands proof of imminent harm. The speech must create a direct, immediate threat to public order to justify intervention. Media trials evade this role entirely. They do not trigger riots. Instead, they inflict damage through a slow, cumulative reputational burn. The harm stretches over months of continuous broadcasting, purposefully staying below the threshold of imminent physical danger. This doctrinal blind spot provides legal cover for highly aggressive press scrums and speculative reporting. As long as the cameras don't physically obstruct the courtroom, the law treats their output as protected speech. The free speech architecture was built to protect newspapers from state censors in the 1950s. It is structurally blind to the diffuse psychological harms generated by the digital ecosystem today. To understand those harms, we have to look away from the rights of the press and examine the rights of the accused under Article 21. For decades, the judiciary interpreted Article 21 narrowly. It was seen primarily as a protection against physical restraint, keeping the state from unlawfully locking you in a cell. That interpretation shattered in 2017 with the landmark Puttaswamy judgment. This 9-judge bench decision recognized privacy as a fundamental right, rewriting the definition of liberty. This visualization shows how Puttaswamy expanded Article 21. Liberty is no longer confined to physical freedom. It now encompasses the psychological and social domains of the individual. The first new domain is informational privacy. This grants citizens the right to control the dissemination of their personal data, protecting them against the unauthorized broadcast of private messages or financial records. The court established reputational integrity as a core component of human dignity, recognizing it as essential to the constitutional right to personhood. The philosophical shift is exact. Privacy is not the desire to be isolated. It is the fundamental ability to shape your own identity, free from unjustified, non-consensual interference. Post-Puttaswamy, the reputational annihilation caused by a media trial is no longer a private inconvenience or a minor tort. It is a direct, recognizable constitutional injury. In practice, the public spectacle of a media trial actively inverts the most basic protection in criminal law, the presumption of innocence. The burden of proof is ripped away and shifted onto the accused. They are forced to prove their innocence to a hostile, suspicious public, often through invasive street-level interviews where silence is framed as an admission of guilt. This leads to intense psychological objectification. To satisfy engagement metrics, complex human beings are reduced to two-dimensional narrative archetypes: the mastermind, the betrayer, the villain. Scholars refer to this as narrative dispossession. The individual is completely stripped of their agency, losing all control over how the story of their own life is told to the world. Actual courtroom proceedings are governed by rules designed to end definitively. A judge reviews evidence, applies the law, and issues an acquittal or a conviction. The matter closes. But media trials bypass this closure. They inflict a severe pre-conviction punishment, generating a social stigma so deep that the eventual legal verdict becomes virtually irrelevant to the person's ability to participate in society. Many legal professionals assume we already have a tool to stop this: the law of contempt of court, which penalizes acts that interfere with the administration of justice. But contempt law contains a fatal structural flaw. It is entirely reactive and punitive. It triggers only after the damage is done, and it requires proving an impossibly high threshold of direct, physical interference with the judge's duties. Speculative studio debates rarely meet this standard. The Supreme Court has also allowed for judicial postponement orders, known as the Sahara Framework. However, these are temporary, apply only to specific cases, and are rarely granted because judges are deeply hesitant to appear pro-censorship. Self-regulatory bodies, like the Press Council or the News Broadcasting Standards Authority, similarly fail. They issue moral guidelines, but lack enforceable authority over the independent digital platforms and algorithms that actually distribute the content. And all of these legacy tools are ultimately defeated by one compounding factor: digital permanence. Even when a court issues a total acquittal, the internet does not forget. Search engines and archived broadcasts ensure that the media's original, speculative allegations remain permanently attached to the individual's name. The traditional legal toolkit is entirely outmatched by the architecture of the 24-hour digital news cycle. The constitutional disequilibrium runs unchecked. This leaves us with an existential challenge. How can a constitutional democracy accommodate expressive vitality while actively protecting the dignity of its citizens? The solution lies in the very judgment that recognized privacy in the first place. The Puttaswamy ruling endorsed a specific analytical template called the proportionality framework. This graphic illustrates the four-part proportionality test. Before restricting speech to protect dignity, courts must ensure the restriction meets four strict requirements. It must be sanctioned by law, pursue a legitimate aim, prove absolutely necessary, and be proportionate in its impact. By systematically applying this framework, courts gain a mechanism to issue temporary, highly calibrated restrictions during active trials. They can protect the accused without resorting to blanket authoritarian censorship. The goal is not to chill legitimate investigative journalism. The press must remain free to expose corruption and procedural failure. The goal is strictly to outlaw the unchecked simulation of adjudication. The true legitimacy of India's legal system relies on finally acknowledging this horizontal harm and operationalizing the right to dignity, curing the constitutional disequilibrium once and for all.